Contractual obligation series covered lockouts and dating site contracts. Today we conclude the series with a breakdown on what to do if one organization tries to employ the services of an individual already under contract. Attorney and legal correspondent David Lesch joins us to further discuss this topic. David, welcome to the set.
Sylvie, it's nice to see you again. It's been a good 2.5, 3 months now with the contractual obligation series, and as you said, we've hit a couple of topics. I'm going to end the series today with a contract that I thought made sense to end with. It has to do with the tortious interference of a contract. In other words, it's when somebody forces another party to break a contract. I'll give you an example. Right? Let's say you're here and you're working for BronxNet and you have a contract to be here and to be on set. Let's say another rival television station comes in and entices you to break the contract with BronxNet. Well, that would be a tortious interference with a contract. BronxNet would have a lawsuit, would be able to bring a lawsuit against the rival television station. That's the type of example when we talk about tortious interference. Now, a tortious interference is exactly what it says. It's called a tort. It's a wrong, as opposed to a breach of contract action. Now, a breach of contract action, you bring it within 6 years. A tortious action, where you bring it for somebody doing something wrong, is only 3 years. So it's very important that you understand the difference between the two. So you only have 3 years to bring one, 6 years with respect to the other. Most people understand their contractual obligations and know if they don't meet their contractual obligations, they can be sued. But most people don't know that if they interfere with somebody else's contractual obligations, they also can be sued, or they can bring an action if somebody's interfered with their own contractual obligations. So it's very important that viewers understand that they have this right, which goes all the way back to Roman times, when you had masters and servants who were employed by masters, and if another household accidentally hurt a servant, that master could bring an action against the other household for interfering with their contractual rights with the servant. So that's how far it goes with respect to history. And we adopted it in terms of the common law back in the 1850s, when a theater owner enticed a actor to leave a theater to work for another theater. And that's when we recognized the right as well. So it's very important that you understand that you have this right, and you have to make sure that you know how long you have to bring the action. It's much less than a breach of contract action. I'll give you a couple of ones that have been in the news lately that I thought are fairly interesting. I thought there was one that was a co-op owners wanting to erect a tower on top of their building, and they contracted with AT&T. AT&T actually, sought them out because they had one of the higher buildings in the neighborhood, and basically said, "Let us put an AT&T tower for better cell phone service for the community, and we will pay you your co-op building a certain amount of money." They said, "That's a great idea. It's a good way to raise money for our building, and it gives you a chance to increase your coverage." Well, so what did the building do? They applied to the city just for a permit to allow somebody else to work on the building, which is what you have to do when you usually live in a city. You have to have a building permit. Well, the city denied the permit. Now, for what reason? Maybe because it was obstructing other people's views. I'm not quite sure why the city did this. Turned out that later on, the city wanted contracts on their own so that they could have on their own municipal buildings AT&T towers. So what did the building owners do? The building owners brought an action against the city for tortious interference, because without the building permit, they could not meet the terms and the obligations of the contract. Do you understand? Okay. So they were able to sue they were able to sue the city, and they were successful for the value of the contract. Another example, there's a not-for-profit organization recently that let go many of their staff.
Okay.
What the staff did, because they were so angry, they went out into the community to look at potential donors who had already said that they were going to donate money to the not-for-profit, and said, "Hey, wait a second, don't donate money. Look how bad this not-for-profit is. They let all of us go."
Okay.
So the donors said, "You know what, we're not going to give money now." The not-for-profit brought an action against those employees. They interfered with the contract between the not-for-profit and the donors who had pledged that they were going to make contributions. That's another example. Now, but in all these examples, what do they have in common? First of all, that there has already been a contract. There can't be the point of negotiating to have a contract. If I'm trying to prevent you from going into contract with somebody else, but because I want that job, and there's no contract yet, well, that's not really a tortious interference because there's not really a contract yet. we want in our society competition for jobs and for contracts. Do you understand? So that's
Yeah.
different than if there were actually a contract. The second thing, if you notice in all these examples, there's an intentional breaking of a contract by somebody else.
Okay.
In other words, that person is intentionally going out there and trying to take you away from another station or something else.
I have a question.
Sure.
Even though the donors pledged to make a donation to the non-for-profit, even though is a pledge considered a contract?
Well, in this
that's
particular instance, there was the contract that was probably signed by these donors. Maybe they were given press releases or different things as a result of it. So they were given publicity that they were going to give the pledge. So there was some type of contractual obligation. I don't know all the facts, but there obviously was some type of contract that was between the donors and the not-for-profit. So if it's an accidental breaking of somebody else's contract, well, that's not an intentional. That's not a tortious interference.
Okay.
So therefore, that would not necessarily be covered, so that's very important. There usually has to be some type of malicious intent. I'll give you an example. I thought this particular case was fascinating. There was a pharmaceutical company that was in the process, so this one actually was in the process, and the courts did strike it down as a tortious interference, was in the process of making some type of deal with a distribution company, distributing their own products.
Okay.
A rival pharmaceutical company didn't want this to happen. They wanted that contract. So what they did is they maliciously sent their own person to the pharmaceutical company posing as an FBI agent, making it seem like they were being investigated, so that the distributor would say, hey, wait a second, I don't want to, what's going on here?
Okay.
And they decided, we're not going to enter in the contract with you now. The pharmaceutical company, which lost the potential contract, then brought an action against their rival, who put this phony FBI guy into their midst. Do you understand? Mm-hmm. That was an instance where that was so much malice there that the court said, even though there wasn't a contract yet, you prevented a contract from occurring, from being created, with such malice that we're going to allow the tortious interference of a contract. So that's another example of how the courts are stretching to protect your interests if you have a potential contract.
So what can individuals do so that they're not violating someone else's contractual obligation, as far as even looking at me as a private citizen?
Right.
If I'm, as you talked about with the contract, what can I do?
Well, I'll tell you this. As an attorney, we are protected. We're a protected privilege class. If you came to me and you asked me my advice on a contract that you have, and I said, your contract doesn't look like it's very stable, it doesn't look like they're honoring their end, I suggest you break your contract. I know I can't be sued because I have a privilege as an attorney. You, on the other hand, would only be sued for breaching your contract, so you would be fine. Now, what could you do if you wanted to break somebody else's contract? Well, you have to make sure that you looked at all the obligations that are under the contract, and you never tell the person who's involved in the contract, break your lease, for instance. In other words, if you tell a friend, break your lease, move out, don't honor your contract, well, you could have an action against you by the landlord because you're interfering with the contract between, I don't know, a friend or sister or somebody else. Mm-hmm. So there's really not much you can do with respect to interfering in another one's contract unless you're working for another corporation. If you're working for a corporation and you're not really acting on the corporation and you've somehow interfered with a contract of the corporations, you can still be protected in that way because you're really acting as an agent or a manager, and the courts are giving you a lot of privileges that way. But to be honest with you, you don't have a lot of protection. If you go out there and you are interfering with somebody else's contract, whether it's a car lease, and you tell somebody else don't pay the car payments, and for somehow the car company finds out that you were the one who told the person not to honor the contract, yes, you could be sued for the amount that's left on the lease.
Wow.
So these are things that people don't know, but it is a cause of action, so you have to be wary about it.
Okay. Well, this ends our contractual
That's it, it's over.
series. What should we expect next month?
I don't know. I have to think of another one, another series.
Okay.
I've done a criminal law series. I did a family law series. I'm going to move into something else now.
I look forward to next month.
In September.
Thank you, David.
My pleasure.